Good afternoon, JAS 423 Civil Procedure 2 students. Welcome to our first online, welcome to our first online lecture. Let's get started. I will periodically, if required, pause the video just because it's difficult to do without consulting the rules, even when I have the slides in front of me. So here we go. Let's get straight to it. The courthouse on slide number 3 is the Peterborough County Courthouse. This lecture will only go to slide 20, and we will discuss the first 3 rules this week, 12, 13, and 14. Let's keep going. The first rule to be discussed, Rule 12, amendments, striking out, stays, and dismissals. So simply put, the rules of small claims allow for amendments to the various pleadings that are in play. So it more or less can be kept with the liberal construing of these rules found in Rule 1.03. Just remember, we're looking to move the matter along as quickly and as inexpensively as possible. It is a small claims matter after all, with a limit of currently $35,000 when the book was published. Excuse me. Have a little cough and remain socially isolated as per the government at multiple levels requests. Anyway, so these pleadings can be amended, and they're often done so. Of course, I always say get it right the first time, but sometimes new information does come up and amendments need to be made. But yes, so basically, let's keep going to slide number 8. The various pleadings can be amended. Once they are amended, they need to be served upon the other party, and a very clear, very important, I should say, visual indicator of the amendment is that the amended pleadings are underlined. So the additions made are underlined, and the rules also provide for a striking out, but with a strike through of any changes that amount to a subtraction to the pleading. So they need to be clearly marked for the parties involved. And I just know, for myself personally, when I see an amended pleading, I read the whole thing through, even though often, sometimes, the other side gives you some notice that it's coming. But basically, you got to carefully read through the document at all times and just note any changes. Amendments to pleadings, they need to be filed and served at least 30 days prior to the original trial date, unless on a motion the court orders a shorter time, as we see in clause 12.013a alpha, or request for a clerk's order on consent with the other party, allowing for a shorter time. There we have clause 12.013b or Bravo. Service is then affected afterwards, but as the case may be, for Rule 8.01, personal alternative to personal service may be made. Yes, and it has to be served upon all parties, including any party in default. Let's move on to Rule 12.02. Okay, so this is a rule. This is a rule that is a party who sees that there is a clear abuse of process underway. So let's say the document discloses no reasonable cause of action or defense. Basically there is something wrong with the pleadings, or it's all or part of the document may delay or make it difficult to have a fair trial, or is inflammatory, is a waste of time, is a nuisance, or an abuse of the court's process. there, you find 12.021A or 12.021B or C. Okay, then in that situation, party may bring a motion to strike out or amend all of it or part of the pleading. So that is sort of, that is one would say a key element to a diligent litigant or litigator watching, just to make sure that this is not an abusive process. Litigation at the best of times is contentious, so the litigator should watch for that. And if you're working in a clerical role, I don't know, I'm not quite sure where you'll be working in a couple of months, and I hope it's not delayed on account of what's happening out in the wider world. But again, it's just something, if there's something noticeably wrong with the planning or doesn't disclose a real action, a striking out or amendment may be made. In the above, the court may let's look at subrule 2, so 12.02 subrule 2, the claim may be stayed or dismissed. The defense can struck or a grant of judgment for the other party, and the court may impose such terms as are just. So, the court has considerable power to dispense with the issue, the matter, or the hostile negative aspect of it that as may be required. Let's go on. Slide number 2, and if we just sort of look at Rule 12.02, Subrule 3, Clause 7, okay, and, well, let's look at 12.02, Subrule 2. In connection with an order striking out or amending a document under Subrule 1, the court may do one or more of the following. Number 1, in a case of a claim order that the action be stayed or dismissed. In a case of a defense, strike out the defense and grant judgment. In case of a motion, order that the motion be stayed or dismissed, and impose such terms as are just. So there you have it. Basically, the court has considerable power to stay or dismiss a motion, or stay or dismiss a claim, or strike out a defense and grant judgment. So there's considerable power for the court there, if required, to deal with things that shouldn't be there in the first place. Okay. Okay, so just if I can go back over Rule 12 more generally, and this is something that you just need a sort of sense of. There's considerable latitude, and always recall Rule 1.03. That's my favorite rule. The equivalent rule, the Rules of Civil Procedure 1.04, 104, being my favorite rule in the Rules of Civil Procedure. Just remember that if there's an abusive process going on or a mistake has been made, there's considerable width for a court or a litigant to deal with that as the case may be. Okay. Settlement conferences and offers to settle, Rules 13 and 14, and this is what we will be covering today. So, again, in keeping with Rule 103, settlement conferences are there prior to any trial to help the litigants come together and see if settlement is indeed possible. So the rules of small claims, and I'm looking at slide 14 right now, encourage settlement. So scattered throughout, there are places that encourage settlement. So I've cited some examples here. Rule 9.03, proposals for terms of payment. So if we need to, at the very beginning, just sort of, let's get this matter done and propose rules for payment, we can have Rule 13 with the settlement conference, what we're talking about now, and Rule 14, offers to settle, and sort of what ramifications those have within the larger context of litigation. So at a settlement conference, It is an informal meeting between the parties, their legal representations, before a judge, deputy judge, or a referee, and a referee is a non-judge. But you will basically come into a room which typically has sort of a desk there with a perpendicular table for the various parties to come in, put out their documents and whatnot, and basically just sort of see if it is at all possible to hash it out. If there's an offer there, the deputy judge will, Mr. Stewart, do you have an offer? Madam so-and-so, do you have an offer? Type of thing. And so, it's also an opportunity for a deputy judge or judge or referee to give their assessment. So they've read all the documents, involved, the pleadings, and so they're there to give a full and frank opinion as to where they see this going. And they can go either way, right? You can, it's as I've said so many times in this class, it's a human process. So you're not quite sure, which way it's going to go on that particular day, but you'll get, in most cases, a frank opinion. So they shall, and let's just look at, and I'm going to pull the rules up here right now. Settlement conference shall be held in every defended action. So it's look at the very first rule, sub-rule 13.011. Settlement conference required in a defended action. Settlement conference shall be held in every defended action. So they are mandatory. They are important. They're to be done, of course, within 90 days after the first offense is filed. So again, what's going to happen in a post-COVID-19 world, I'm not so sure. But again, it's important to get on with the thing. And there you bring along with you the clerk's. There is a blank list of proposed witnesses for the parties, and that's one of the documents you bring. Form 13A, and notice of settlement conference. Okay, sorry about that. I just needed to check the rules, but so the point of the settlement conference is basically, the purposes. Rule 13.03, sub-rule 1. The purposes of the settlement conference. The purposes of the settlement conference are to resolve and narrow the issues in the action, expedite the disposition of the action, encourage settlement of the action, assist the parties in effective preparation for trial, and provide full disclosure between the parties of the relevant facts and evidence. So disclosure, just continuing along through the rules, and right now I'm at the annual practice. I'm at 2044. That's page 2044. Rule 13.03, sub-rule 1. Basically, the idea here is to provide the other party with a list of witnesses or proposed witnesses, and just try to hammer out some kind of agreement if it's even possible. So so that's sort of how it goes. Again, now up to slide 16 with regard to the whole purpose of the thing. And then what happens after that? Well, how do you prepare for a settlement conference? Again, this is sort of not really going to be utilized in your bailiwick going forward, but again, it's just sort of part and parcel with the rules. When a key element of a settlement conference is disclosure. So you prepare a full and full disclosure as early as possible to the other party. You have your 14 days prior to the settlement conference, each party or their and their legal representative shall serve and file copies of all documents and the list of witnesses which they intend to rely on. And there is cost sanctions under the rules against any party who fails to adequately prepare or file the material under the rules. So basically, if we're looking at on the annual practice at at page 2044, and we go through the rules, you see there's all sorts of mandated in the rules, sort of what you need to do to prepare for a settlement conference, and just sort of the the bureaucratic niceties that the rules require to get ready for such a thing. So it is, and so let's keep going. So we're now on slide 18. Okay, sorry about that, just coughed. Again, social isolation requires that I stay here. But so if we just look at Rule 13.02, and just sort of, this is sort of the final element of the settlement conference and what it's all about, is that the rules provide for what must happen. So the parties and the legal representatives, if they are there, they must participate, they shall participate in it. The party in attendance must have the authority to settle. The whole point of it is to try to hammer out, some form of settlement. So again, you have to have the parties there who have the authority to settle. Personal attendance can be made by video or teleconference. This is obviously going to be a big thing happening in the future. And the judge or the deputy judge, who is there at the time, obviously cannot participate in the subsequent trial if, in fact, the settlement conference is not, is not successful. So that just, is axiomatically, about fairness there. And the judge can make recommendations on any matter and to fulfill the purposes set out in the rules. So, the judge will make orders with regarding the conduct of the action, can provide a recommendation of a referee, and is frankly there to give that full opinion. The judge may order a final judgment if the amount is less than $2,500 if there is consent from all parties, and this is manifested in a Form 13 Bravo, 13B. Yeah. And, okay, sorry about that, another cough, but just, just looking at sort of Rule 13.05, the orders at a settlement conference, the judge conducting the settlement conference may make an order relating to the conduct of the action of the court, and without limiting the generality of Subrule 1, judge may make an order for, and I'm looking at page 2045, Rule 13.05. There's considerable leeway and considerable power for a judge to do that. To make orders adding and deleting parties, consolidating action, written reasons, staying or dismissing an action. So obviously written reasons means there has to be some sort of rationale behind it that can be scrutinized. Directing the production of documents, changing the place of a trial under Rule 6.01, directing an additional settlement conference, that happens a lot, and ordering costs, and at an additional settlement conference, order judgment. So there's considerable power for the judge from that point to get the trials to do, get the parties, I should say, to do certain things. And yeah, so we'll just sort of, in conclusion, what happens if a party fails to attend? Cost order may be made against them, and I'm just on slide 19 now. And the court may order an additional settlement conference. And if they fail to attend a second settlement conference, the court may strike the defense, allowing a plaintiff to prove the claim without trial. So basically, if you're not showing up, then it has maybe a similar effect to a default judgment from there. Afterwards, after a conference is held, plaintiff cannot withdraw a claim against a party without written consent or leave of the court. So, it's sort of a past the point of no return. And a clerk can provide notice that if no settlement happens within 30 days after the conference, party must set the matter down for trial. So, okay, settlement conferences. Again, broadly speaking, with the nuances of the rules, you know how to find it at this point. But what I'm just going to say is really it's just an opportunity to get in the room with sort of someone with the gravitas, a judge or deputy judge, someone with sort of, can give an assessment of the court, can order a number of things. We need a production of documents. That sort of thing. basically square up the matter for it to move forward, or to offer a frank assessment if if settlement can be reached between the two parties. Okay, I'm going to take a little pause right there. Okay, I've sort of changed my tune here. I see now we're at slide 20. I'm going to do, excuse me, settlement offers in the next lecture. I see we're at 20 minutes, so I'm going to stop right there for the day. It is a little bit later in the day, and so we'll stop there. But again, thank you. This is the first lecture. It's proving difficult to do this, but I will get better. I promise you that. So I very much appreciate your patience with me, and with the program generally. We are in uncharted waters, but I'm very appreciative of everything. So thank you. Have a good day, and I will speak with you in a few. Take care.